One of the things that I get consulted on a lot is when somebody has been left out of a will and feels that this was done inappropriately. Really, what your rights are in that scenario depend on who you are and who you are in relation to the testator, the deceased. If you are a dependent of the deceased, then there are mechanisms that we can put in place to ensure that you are supported. If, on the other hand, you are an adult who is independent and have been left out of the will, it can be challenging to have that will set aside. It can be, unless you can show that the will is the product of undue influence or was drafted at a time where the testator didn't have legal capacity, then the will can potentially be set aside. And if there's no prior will, then the Succession Law Reform Act comes into place and assets get divided in that way. If you are a spouse, then again, as dependent, there are some assets that you can partly seize, but also the Family Law Act will deal with many of those assets that are under that act jointly held. And the premise of a will is that the testator can give away the stuff that is theirs as they see fit. There are scenarios where either as a dependent child or as a spouse where the what is theirs becomes the question. And that needs to be determined first before the rest of the estate can be dealt with. So realistically, what your rights are if you've been completely left out of a will depend on who you are vis-a-vis the dead, the deceased.